That we have parallel structures that exist, one for regulation with respect to the insolvency of persons and enterprises, and other for the purpose of persons and companies agreeing on the method in which they will resolve their disputes, for the purposes of our discussion, commercial disputes. And we have a very unique situation today in the world, which is the spread of COVID-19 and the effect that that is having on the economy, and the clear tendency that that disruption will have with respect to bringing those two worlds together, the world of international commercial arbitration and the world of insolvency. There will be arbitrations that will take place outside of jurisdictions in which one or perhaps both of the parties are either subject to insolvency regulation or administration. The actions of the administrator in that circumstance may produce effects in the context, for example, of arbitration that would not necessarily be new, but in the old order be unusual, but that are today becoming more and more commonplace. One question, of course, is the simple ability to execute on the arbitration agreement. When a party to the arbitration agreement is subject to special regulation under an insolvency regime, how will that special regulation affect the ability of the parties to resolve their disputes through arbitration? And if they do, in fact, resolve their disputes through arbitration, the ability of, for example, the prevailing party to execute upon the result of that process, which would be a favorable award. So I think that the future, at least the immediate future, will bring these two institutions, which in effect have some similar characteristics in terms of their end goal, but that have very different origins and backgrounds. Arbitration coming, of course, from the consent of the parties, insolvency coming from the power of the state to reorder situations in which a party who, prior to the invocation of the insolvency regime, was relatively free to order its affairs, now finds those affairs ordered through the filter of the insolvency regime, and what effects those will have on international commercial arbitration. Some of those effects, I think, are still to be known. One thing that we know when we look at international contracting is that the basic institutions and rules, I think if you look in terms of the international contract right, for dealing with a situation like COVID-19 exist. The effect that COVID-19 will have on the development and expansion of some of those principles, I think is still very much an unknown. If we look, for example, at force majeure, hardship, impediment, impossibility, frustration of purpose, there is what we would call a juridical infrastructure that exists in terms of rules and norms for dealing with those situations. But can that system deal with a situation of the type that we are dealing with at present time and that we will in the future have to deal with? Remains to be seen. And like any system, it will have to respond to pressures, it will expand, it will contract. There might be aspects of it that will break and cease to function that need to be fixed. And I think that is the challenge that we're all going to be facing with respect to the intersection of those two concepts.